I'm going to pick some high-level stuff and deal with it that way. There is a whole set of desk recordings on certainty as well, which are basically available to you at any point. I made sure that they're available just in case somebody wanted to get a head start on the assignment over the break. But what is certainty about? Oh no, that's just our introduction slide. No, I'm not remembering what order I've got slides in. Let me just talk about what certainty is about before I get there. There are basically three elements to certainty. One is just about being certain. So understanding what the terms are, so what they mean. So that's about reading contracts. The next is about completeness. Are all of the terms there? Are the parties sure about what they intended based on all of the terms? And then the third one is this issue that Jack raised just earlier tonight, the one about, are the promises real promises? Are they certain promises? Or are any of them illusory? So in typical roundabout lawyer fashion, we look at this in the negative. Is it not illusory? To be certain, it must not be illusory. So where does this fit? And we keep coming back to this model over and over again. If we're solving contract problems or problems about contract, and our threshold question is there a contract? We need to be able to answer that before we can ask who can sue for breach of that contract. If there isn't a legal contract, we might be able to think about whether there are other ways to deal with something, but there is, it's easier for us to resolve an issue if we can find whether the contract exists or not. So we're still at this question stage of, is there a contract? And that's what we're going to complete today. So in the whole big map of answering questions, we're just at this very beginning stage of, is there a contract? So still also thinking about these elements of the contract, 4 elements, agreement made up of offer and acceptance, or if we can't find those 2 things, a meeting of the mind perhaps, consideration, intention and certainty, which now is made up of these 3 elements of certainty. All of those things together are what we need to have a contract. Failure of any one of them means no contract. Now we tend to look at them in that order, roundabout. The reason for that is certainty, intention and consideration are all really bound up in many ways in offer anyway. So in working out what an offer is, do we have an offer that's capable of acceptance? We need to actually know, is it capable of acceptance on its terms? So are those terms complete? Was there intention that if the offer was accepted, that there would be an agreement? And how do we know that? It's based on the language that the parties used and the ways that they behave. So they really are tied up. Offer is kind of the biggest element in a sense. So we're still at that first stage here. So let's remind ourselves again. I've just spoken to that. And this is where I wanted to get to. These 3 elements of certainty. Is the agreement sufficiently certain? So do we know what the terms are? Do we know what the offer was? Is it sufficiently complete? Is there anything missing without which we can't have an agreement? So in particular, where that often happens is, do we see consideration? Because if there is no consideration, often that's where the certainty falls over. It's insufficient, the agreement isn't complete because it's missing that material element. But there are other essential terms that if they're missing, we won't have certainty. And then this negative statement, is it not illusory? And an illusory promise really goes to discretion. So let's pull each of them apart. Actually, before we do that, There are technically three different aspects. They overlap with each other. They're termed collectively as certainty. Failure of any one of them is a failure of certainty, but you might find that all fail or only one fails. It doesn't matter. So let's unpack each of them one by one. One of the main ways that we understand how the law works is by working out what the exceptions to it are. So let's think about what certainty is not. It is not necessary for the parties to consider every possibility and deal with every possibility in order to have a certain agreement. So even in a simple transaction like, I'm going to sell all of my shares to you and you're going to pay me $10 million for them, there are a whole lot of things that could go wrong. So if they're listed shares, the price could go up and down. I say I'm going to sell all of my shares to you. What happens if I issue some more shares tomorrow? Am I going to sell all of the shares I have today, or am I going to sell all of the shares at the time we transfer? We've got, there are all sorts of possibilities of things that could go wrong along the way. We don't have to deal with every single possibility. We just have to have sufficient certainty to know what the contract, what the parties intended. I feel like I'm leaning backwards today. My text is too small. I need to walk over here. Courts do resolve ambiguities and they fill gaps. And when we deal with, when we deal with contract terms, so topics 9, 10 and 11, I think, deal with express terms, implied terms and disclaimers or exclusion clauses, diminishing terms. And a lot of that, particularly when we're talking about implied terms, is talking about the circumstances where the courts will step in and write the term for the parties. So now courts are loath to write contracts for the parties. That's not what a court is for. The court's there to adjudicate on the disputes about the contract, including disputes as to whether a contract exists. The court's job is not to write the contract, but it will fill the obvious gaps. And so we still have that option. So let's look at my flowchart for how certainty works. As I said, we've got 3 different kind of head questions that we need to ask ourselves. Can't remember if I'm doing them in this order, possibly am. Firstly, we ask ourselves, are the terms complete or are they incomplete? Does the document or the understanding, the conversation between the parties omit some essential term that can't be filled by a court? And the way that we do this is we look at essential terms, whether all of the essential terms are clearly addressed. And if they are, it's likely that the document or the agreement is sufficiently complete. We also have to ask ourselves the question, and this may also be relevant to the assignment, about whether or not it's an agreement to agree. And we'll talk about what happens if that is the case. In deciding whether something is sufficiently certain, the next question we have to ask ourselves, is it sufficiently clear? Or another negative of that is it vague or ambiguous? Unclear language can be, if the unclear language is used, we need to understand what it means. We might think about, in that context, what past dealings are. We might think about the extent to which the parties understood each other or had certainty based on prior behaviour. And then the last question we ask is it meaningful? Is it a real promise? Because if a party has very broad discretion as to performance, and accordingly there's an illusory promise, then we don't have sufficient certainty. but we won't have consideration either. They fit in the same space. So let's start by looking at whether or not the terms are sufficiently complete. Okay, so looking at this map, this is where we're starting. So completeness requires agreement on all of the essential terms. So what's an essential term? Price. Price is usually an essential term, not always, but usually. What else might be an essential term? The subject matter of the agreement.
Surely it would depend on the context of...
Absolutely depends on the context. So let's, instead of talking about what terms are essential terms, let's talk about what's an essential term. What do we mean by an essential term?
Something without which you don't know what you're agreeing to, something that's core to...
Something that is core to the agreement that the parties have reached. The things without which the parties would never have agreed to enter into this bargain. So that's why it's things like price, like the subject matter. So all those horse contracts, for example, which horse makes a difference? It's rarely a contract for the sale of any horse. It's an agreement in relation to a particular horse, or a particular piece of land, or a particular kind of service that needs to be delivered by a particular date.
I'm just wondering, like in the context of, like when you describe it as like a thing without which you would never have agreed to the agreement, like I can just envisage circumstances in which that would be quite dependent on your subjective intentions. Like, say I want entering into an agreement to purchase a particular terminal or something because I have interest that in fact this particular region, and that's not known to the other party, but to me it's the location.
So, and you've raised a really, really good issue here. I'm going to repeat for the recording, but the issue is if the test of what's an essential term is whether it's the thing that without which somebody would never have entered into an agreement, then the question becomes, well, isn't that subjective? Thinking back, I didn't hear the word that you used, but thinking back to Kirby and Woolworths talking about how baseball cards or football cards might have incredible value to one person but no value to somebody else. Or Nestle and Chattel, the same kind of thing. Turns out that you're particularly interested in chocolate wrappers. The rest of us don't need to know that. We really don't need to know that. Your particular thing that you're interested in, but we still use an objective test. Well, why would we use an objective test in that basis? So we are still using, in order to work out whether a term is essential or not, we're going to use an objective test. So why would we use that? Because otherwise it's always going to be a he said, she said argument at the end, isn't it? What suddenly you decide is really important to you later on, we don't know, to get the evidence trail. The role of the court is to adjudicate. So if something is important to you, then you need to make it clear to the other party, otherwise you're going to be at risk. Or, if for negotiating reason you want to keep it a secret, you need to make sure you've got a valid contract, that you're not at risk in this way.
So essential terms are determined objectively, but you can look at the interaction between parties.
Yes, you can look at the interaction of the parties before the contract is made. So a lot of people would argue that completeness itself isn't really a formation element. That if a contract is uncertain and incomplete, then the courts can't actually know what's been agreed at all. So completion itself is just a mechanism for knowing whether or not the parties have actually reached agreement. So a contract will be enforced if the parties' intentions are clear or they can be ascertained with reasonable certainty. So, we have in Hall and Bust, which is the key case here, we have this Latin expression. Do remember that we use Latin when the idea is particularly clear in English, I think. So the Latin is ut res magus valeat quam periat. It's better for a thing to have effect than to be found void. So as I said before, the courts are loath to write a contract for you, but at the same time, if it looks like a contract, it smells like a contract, the parties appear to have been contracting with each other objectively, then the court is less likely to find no contract just because a party's putting up their hand at some stage when they don't want to do something, they don't want to be found in breach and arguing there was never a contract in the first place. So on this, particularly on this completeness question, the courts are more likely to find, the test is not high to find that the terms are there. But if there is an essential term that is missing, it is much harder to get over that hurdle. So let's have a look at Whitlock and Brew. So this is a case that went to this, well, what's reasonable or fair? So part of this is about reading the contract as well. So in this particular case, the plaintiff, I think it was a plaintiff, went to purchase a property, and the terms of the contract said that the property would only be sold to a purchaser who was prepared to grant a lease of that property to Shell, so a third party, on such reasonable terms as commonly govern such lease. So this was, the use of the land would be for petrol storage. It's a fairly unusual lease, fairly unusual terms. Like there are pieces of ground that people have rented out for the purposes of storing fuel, but there aren't huge numbers of them. So what do you think happened in this case? Has anybody had a look at it? So in this particular case, the court came back and said, well, we don't know what would be reasonable terms commonly governing this lease. There was no evidence that was able to be presented as to what those terms would be. This is not a common contract. So in Hall and Bust, the court found that there was no lease. There's very small text here. The expression upon such reasonable terms as commonly govern such a lease was not, in the context in which it appears, apt to refer either to the period of the lease or the rent payable. So essential terms in relation to renting land to somebody would be what land, but for what period of time, and for what rent. And I would suggest in relation to petrol storage, probably what clean-up cost, who's going to be responsible for dealing with EPA permits and things like that. There are a lot of particular provisions that would be relevant to that particular type of agreement. So does this mean that if I want to sell a property to you, so I'm going to sell my property to Sarah, on the basis that she's going to rent the property to Alyssa on terms, such reasonable terms as would commonly govern such a lease? Is Hall and Bust authority for the provision, or for the proposition, that in the absence of any other terms, that would be an insufficient or an incomplete agreement? Insufficient? And in a very ordinary house,
I think it's
very easy to work out what the rent would be.
quite different to this case because this was a very unique, just common terms, there were no such common terms.
There were no common terms. Where my very ordinary house in a very ordinary suburb, it's pretty easy to work out what the market is, what the rent would be, what would be a reasonable rent, what would be a reasonable term for a lease. You know, most leases will be more than 6 months, less than 2 years. We can, you know, it's not hard to find that. But each case we have to look at on its merits. SJ?
I'm just wondering, in that I work in the legal department with perpetual companies, this is quite interesting, but if there, say you had a similar situation, but you know, not 1968, it's a more modern case, and the contracting parties, with exactly the same words, but the contracting parties do business with each other quite frequently.
Okay, this is something, so contracting parties who do business with each other quite frequently, we have then got a situation where we can work out what's reasonable.
Even if there's no reference to the rent or whatever, if you've got that.
Quite possibly. I mean, again, every case, and the point of raising this here is every case you need to look at on its merits. Again, I really love those words from that case that came up on last week. Don't worry about what the parties meant by their words, look at what the words and the actions mean. So we know if parties have contracted with each other 100 times, we know what's reasonable is probably going to sit in the middle of their price range and in the middle of their terms. If suddenly one of them says, well, we need to do it for twice as long and half the price, it's probably not going to be reasonable. But words like reasonable or fair open up that question for us. Is it certain? What is reasonable or fair? Is there a benchmark? So obviously though, I mean, who in their right mind would want to leave that to the courts anyway? Wouldn't we be better off saying the property will be sold to you on the condition that the purchaser will grant a lease to Shell for 5 years at no less than X rent, or on the terms attached to this contract? And you do it as a multiple deal. Now, in this particular case, it was the vendor who wanted to get out of the contract. From memory. Oh no, we get to that one later.
Would the inclusion of a third party bring uncertainty in itself?
Well, it can, absolutely. Because you've got this third party arrangement, somebody who's not a party to the contract, and we'll talk about that when we get to privity, who there's a condition that's attached. So I would be thinking, if I was acting for either party here and I wanted the deal done, so we have to assume that our clients actually want to do the deal, they don't always, I would be wanting to see this all happen on the same day. If I'm acting for the purchaser, I don't want this other contract hanging in the balance. So I want to know what the terms of that are going to be, and that Shell in fact are prepared to do it and how that's going to work. And it's kind of, when you think about it, if you're buying a property that you're not actually going to inhabit yourself in some way, you want to know what the return is, what the commercials are. If I'm the vendor of the property, I don't want it to fall over. I want to get my purchase price. I don't want it to fall over because of something that a third party's holding me over a barrel for either. I want to see it all happen. So as the lawyer, this is where the control freak in me sort of wins the day. So I want to think about all of the steps I need to complete my deal, not just the bits my client wants. So, when we look at what the essential terms are, and we'll come back to talking about essential terms when we look at reading the contract. Colours here are terrible, but we ask ourselves, are all the essential terms clearly addressed? Who are the parties? What are the subject matter of the contract? What terms there are? What period of time the contract runs over? What's the price? And each will depend on the type of agreement itself. We also need to look out for agreements to agree. An agreement to agree at some future time is not of itself enforceable. At the very best, depending on how it's worded, it's an agreement to get people in a room. But an agreement is a very binary thing as far as the law is concerned. For an agreement to be enforceable, what does it need? Oh, surely you know something now. Thank you. We need consideration, we need certainty, we need intention, we need to have agreement, as in offer and acceptance and a meeting of the minds. Okay, so an agreement with all of those things, to agree something in the future makes no sense to us anymore. Okay, I know it made lots of sense to us ages ago. Now think about it in social context, how we do that all the time. We say, oh look, we'll get together on Saturday night and we'll agree where we go then. Socially that makes sense. I know agreements to agree make so much sense to our clients all the time. It's just like, oh, we don't know what all the factors will be in the future. So once we know what we're fighting about, we'll agree how to resolve it down the track. We can't agree to agree. We can agree to talk, we can agree to negotiate, we can agree to mediate, but we can't agree to agree. And now I think you're probably down the legal minefield enough, down the legal rabbit hole to get that that logic makes no sense. We've either agreed or we haven't agreed. We have all of the elements, but we can't agree to agree. We can agree to negotiate, we can't agree to agree. So, in working out whether a term that is missing is an essential term, we need to look at the circumstances of each of the case. Now, well, that's actually what we've just been talking about to this point. Key case here is Tramways and Luna Park. It's worth a read. It's one of the regularly cited cases. It's a case where Luna Park, New South Wales version, I'm sure everybody knows it's a theme park. It entered into an arrangement with Tramways Advertising, which basically said that its advertising would be on trams that would be out and about for at least 8 hours every day. 2 years into the contract, they said, look, this isn't working for us. Our advertisements are not on the trams for 8 hours every day. And Tramways Advertising didn't control the trams. Okay? Part of the problem arose because there's a third party involved. And it said, well, hang on a minute. They're on the trams that are out and about for an average of 8 hours every day. If we look at all of the times that they're out and about, it averages out to pretty much 8 hours a day. So we haven't breached our contract, so you're purporting to terminate. We need to have the balance of payment. And Luna Park said, well, no, that's not what the agreement says. The agreement says we're guaranteed to get 8 hours every day. Guaranteed 8 hours every day is different from an average of 8 hours every day. So ultimately it came to this question, was that an essential term? Now why, it's not necessarily a question about intention here, but it fits into that same category, because if we don't have an essential term, if an essential term is missing, then we don't have certainty. In that particular context, it arose because if there is a breach of an essential term, you can terminate a contract. If you breach a contract but you don't breach an essential term, then you can only get damages. So the classification of the terms are important for other reasons as well. So a lot of our understanding of what's essential and what isn't comes out of Tramways, and it looks to the circumstances of the case, and it looks to the relationships of the parties, and it takes again that objective test. Doesn't matter what you meant by what you said, what matters is what people heard from what you said. And it also looks to the existing relationship and balance between the parties. So, what kind of things are essential terms on the whole? Pretty much who the parties are will always be an essential term. Identifying who the parties are. Now, sometimes you'll be contracting with an agent who, for an undisclosed principal, but that's actually between that agent and you. If you don't even know that the agent is acting for somebody else, you've entered into a contract with somebody, you're entitled to believe your contract is with that person. When we talk about privity, a lot of the issues as to why the parties, we need to know who the parties are, makes sense. So that issue arose in all things carbolic and Carlisle and carbolic smoke ball. Because one of the arguments that Smokeball had was, well, we didn't know we were in a contract with Mrs. Carhill. We didn't know anything about her. We didn't know she existed. We were just selling our wares to whoever came up. We couldn't make a promise to her. It's an essential term of the contract to know who we make our promises to. Subject matter of the contract.
What about that instance where you subcontract?
Subcontract?
Yeah, would you have to?
Okay, let's work out the logic. So I've got a contract with you. I'm going to build you some cubby houses. I'm actually not a very good builder. I'm not interested. I'm going to outsource that building to Meehan over there.
I'm a very good cubby house builder.
Very good cubby house builder. Okay. Turns out this particular time though you didn't read the specs particularly carefully. You built a little bit big. Okay. So firstly, we have an issue here. I've delivered the cubby houses. Here they are. They don't work. They don't fit in your particular space. Can you sue me?
What about if I say that I wanted you to make the cubby house? I wanted your name. I didn't want her name on this cubby house.
So,
Yeah.
well, you would need to have a specific term in the contract that required that. We'll talk about specific performance at one stage. But in the absence of that term,
Yeah, I didn't expect you to go and say,
yeah, I've probably breached the contract already.
Yeah.
In relation to the cubby houses that aren't built to spec, have I breached the contract or has Meehan breached the contract?
I'd say you have.
I've breached my contract with you. It's pretty unclear whether I've actually specified. I've probably just said to you, build me some cubby houses. I may or I may not be able to sue my subcontractor or not. So whether or not, if it's essential to you that you get the performance of a particular person, and we'll talk about this, it will come up in a couple of places, but spoiler alert for the law, it's very difficult to hold a human to an order of specific performance. You can't make a human work or prevent a human from working. So terms that specifically require somebody to do something or not do something are really difficult to enforce. That's a very general rule, and we will come across it in more detail later on. But this is one of the reasons why employment contracts are a particular area of complexity in this regard. So you have rights and obligations as an employee, and you can be in breach, but if you decide to breach the contract, you can terminate it, even though it might not be an essential term. You can terminate your contract, and you can terminate an employment contract. You can't actually specifically require, you've quit, well, I'm not accepting your resignation, you're going to have to come to work today. And some places where that doesn't work, particularly in relation to the performing arts, it's just like you can't substitute me for Adele. I know she asked, but what the hell? She had to go and perform herself even though she was a bit snotty, because I can't be substituted in that situation. But at the end of the day, you can also, it's very difficult to make a human do something in a particular company. Anyway, off track a little. Price or an effective mechanism for determining it. So sometimes we don't need to know exactly what the dollar amount is, but we do need to know how we're going to work it out. And we've spoken about, the example I'm going to use is options. We've talked about options for leases a number of times. So an option feels like an agreement to agree, but it's not when you think about it. What it is an option for premises is an agreement to hold an offer open for a period of time. And essentially it's like, I'm going to lease my premises to you for 3 years, and at the end of that 3 years, you have the exclusive right to renew that lease on exactly the same terms, but usually the rent will change. But it won't be the rent, it can't be the rent we'll agree at the time, because that would be an agreement to agree. It'll be rent calculated by reference to a number. So often that will be the rent you're paying now plus CPI or 0, whichever is the greater, because landlords on the whole don't like it when their rents go down. Okay? Time periods. When you have to start doing something, when you have to finish doing something, they tend to be essential terms. Specifications might be essential terms as well. So the particular size, height, weight or colour of something. But it will depend. So, some kinds of agreements, the courts have developed kind of shorthand for what will always be essential. When it comes to the sale of land, what land? The specific identity of that land will always be an essential term. Now there are some, you might be able to get around, I'll sell you my house, but that's only going to work if it's very clear, I only have one house, we all know exactly what it is that I'm talking about. Sale of goods, the goods themselves, but not necessarily the price in relation to the sale of goods, because the legislation itself can imply a reasonable price for goods if that can be determined. Milne and the Attorney General of Tasmania, why have I concluded that? Basically, Milne is the authority for the objective test. So we've already spoken about this. So here what we're doing is we're looking at whether what it takes to identify these, what the terms are. So apart from the fact that the general purport of the communications in question evidences anything but an intention to affect legal relations, so Milne, we've already dealt with that problem, the documents deal with some only of the terms which must of necessity be settled before a binding contract can exist. So again, think about that when you're looking at the assignment. What have they actually agreed? What's missing? So, little grab bag of cases for you. When you're looking at completeness, think about how important or how essential is the term itself. I've used as authority there ANZ Banking Group and Frost, and that's not the case that we spoke about. Look at Luna Park will actually help you there as well. Why was the term left out? Did the parties fail to reach an agreement? Did they defer agreement? Did they fail to turn their mind to the issue? So we've said at the beginning that in order to be complete, you don't necessarily have to have dealt with everything, but the courts will take into account what happened during the negotiations. So if something was left out intentionally because the parties couldn't achieve agreement on that point, then the courts will take that into account. And when we talk about formalities, that's one of the issues that you're going to need to think about, is whether or not evidence of the discussions between the parties is admissible when you've got a written agreement. Because it will be admissible for the point of working out whether something was left out on purpose, so that we don't have to imply it in, or whether it's just incomplete for that reason. Courts will take into account whether an agreement is wholly or partly performed by one of the parties. So they're more likely to find that an agreement will be complete if one party has done everything that they promised to do under it. Because using an objective test, it makes sense then to find as closely as they can that the other party has made the promises that make sense. And how equipped is a court to imply a term to fill a gap? So that's something that we will spend a lot more time on in topics 9, 10 and 11, particularly topic 10. But those words just on the previous slide from Milne and the Attorney General are essentially a good pointer there. It's not the role of the courts to write the contract. And the court looking at that contract is saying, well, the parties haven't actually turned their minds to the essential terms. It's not for us to do that. Spoken already about formulas for settling the term. Rent increases as per CPI is a good example. If the mechanism or the machinery itself fails to supply the essential term, then a contract can still be void for uncertainty. But one of the things that is, as a junior lawyer in particular, you'll get asked to check over and over again is when there are formulas in contracts. A very wise partner said to me once, always run numbers through every formula. Really go and check whether or not it actually makes sense. Run a number of different scenarios, because if the formula doesn't work, you end up with uncertainty. I mentioned the Goods Act previously. So we can end up with a situation where you can agree to sell at a third-party valuation. This good example of this is when somebody is selling goods at an estate auction or in a liquidation or something else. So the Goods Act basically says if there's an agreement to sell goods on terms where the price is to be fixed by the valuation of a third party. So let me give you an example where that might happen. Our Kirby House business, we can't resolve the fight that we've had, and you've decided to just close down your business. You and Michael, you were in partnership there with this Kirby House business, and you've decided that it's all just too hard, so he wants to continue on, you don't. So you agree to get a valuer. Justin over here can be your authorised valuer. He's going to come in and value the assets and the contracts at that time, and Michael's going to pay you half of that number. That's a perfectly valid contract, and quite a usual one, particularly in a business bust up. We get an independent third party who's qualified to do the job to come up with a number, and one party can be bound by. Those of you who come to M&A with me, we can fight then about Russian roulette clauses and all sorts of things that people can do to try and manipulate, because it might be chef doesn't, well, he just wants Michael out, so he's prepared to pay, you know, he'll pay $1 more than Michael will, and they'll work out which is, you know, which way to go. Each has to make an offer, and the one with the highest offer wins, all those kind of clauses. But the Goods Act says in relation to goods that you can do that, provided that if the goods or any part of them have been delivered to and appropriated by the buyer, then they need to pay a reasonable price. Agreements to negotiate, I think we've spoken enough about those. Actually, we've got some cases in there that you can have a look at, but let's move on and talk about terms being certain and clear in their meaning. So this is the next element of the three. And looking at this, it's really just asking the question, are the terms clear and unambiguous? So in order to be certain, terms need to be sufficiently clear so that the parties can understand the rights and obligations that they have, and the courts can enforce those rights and obligations. So if they're not certain, there's nothing for the court to adjudicate. And remember, going right back to the first week when we talked about what a contract is, usually we think about the contract as being the lowest common denominator in the relationship. People can do more than they promise, but your legally enforceable agreement sets out your minimum set of rights. Even so, courts don't usually take a narrow approach to the requirement of certainty. They'll attribute meaning to the language that the parties use unless it's impossible to make sense of them. So on the whole, when looking at the terms, they think about the context, they think about what the parties might have meant, and they try and make sense of the language. So we look at the language that's used and we ask ourselves, is it so obscure or incapable of any definite or precise meaning that a court is unable to attribute to the parties any particular contractual intention? Notice how certainty and intention are wound up in each other in this way. So basically, Chief Justice Barwick in Upper Hunter County, I can never get the name of this. This is another freezer case. There are always, a lot of these cases somehow relate to electricity supply and freezing. So Chief Justice Barwick's words are, whether the terms can be ultimately and logically worked out, if not by the parties, then by the courts. So, having said that, interpretation itself isn't always an easy thing. Think about the types of words I've got on the slide. The timber to be used in building the house needs to be of a high quality. What does that actually mean? Doesn't really mean anything. High quality, like, does that mean, is it hardwood or softwood? Is it a particular grade? Does it meet a particular standard? Does it just mean that it's the minimum standard that's allowed in building materials, or is it higher? How much higher? What does that mean? Fresh eggs. The eggs must be fresh. Does that mean they still need to be warm from the chicken's bum? Or do they need to be not outside a best before date? The rent needs to be a reasonable price. Reasonable to who? It's not always easy to identify what terms mean. So let's look at Australian chilling and freezing. So this is an electricity supply case. So the council supplied electricity to Australian chilling and freezing. And clause 5 of the contract provided, and turn around so I can read it properly. So the parties have agreed that during the term of the agreement, if the supplier, so Upper Hunter Council, shall vary in other respects than has been herein provided, let's turn that into English, shall vary in ways that we haven't already stipulated in this agreement somewhere else, the supplier has the right to vary the maximum demand charge and the energy charge. In other words, the supplier has the right to change the price that it charges by notice in writing to the purchaser, by giving Australian Chilling and Freezing Company a notice saying it's going to change the price. So the council sought to increase the charges, and the company said, no, that's void. That term makes no sense. It's uncertain. What do we think? Why don't you talk with each other about it first? I feel like we need to wake up a bit. Each of the tables, have a chat, come up with a view. Oh, Jack, turn around and join the people behind you.
Sounds like they can do whatever they want. As long as they give notice.
So think about what kind of thing.
I've been there. Yeah. They've said that.
All right, coming back together again. So what kind of issues can you see with a clause like this? Is this a well-drafted clause?
No. I think it's fine.
You think it's fine?
Yeah.
Okay.
It could be clearer. Why? Yeah. This in plain English form. Yeah.
Plain English is something we all need to deal with. So what does it mean? Okay, Chef, you can be the devotee of this clause. Does this mean that they can put their prices up?
Not in all circumstances.
Not in what circumstances can they put them up? Sorry, you're Jonathan, and I've just put Chef. No, I think I called her him, and he's just talking.
In circumstances not covered in the rest of the contract.
So circumstances not covered in the rest of the contract. So if, for example, let's assume that line charges, you know, transmission's owned by somebody else these days, everything's separated out, so their line charges go up by 5%. Does that mean that they can put their overall price up by 5% if it's not covered anywhere else in the contract?
Yes.
So line charges might represent 2% of their overall price. So they're just going to put the whole thing up by 5%. Or do they put it up by cost? Do they put it up by cost plus? What does it mean?
Doesn't say any of that.
Doesn't say any of that, does it? It just says if our costs change, we can vary our price.
Yes.
In fact, it says, so does that mean that if their price goes down, the costs of supplying electricity goes down, do they have to, in ways not otherwise contemplated by the agreement, do they have to put their prices down?
They have to.
They don't have to.
They could, but they won't.
They could, they probably won't. What happens if their prices go down, they don't vary the charges, then their prices go up a bit, can they vary their charges then?
Well, yes. It just
Yes, because that's what it's, if we're going to read it that way.
the prices could go down and they decide to vary the maximum demand price up.
Yeah, well, could they do that? Does that clause say they can do that?
I think it's reasonable. I mean, I would say Australian chilling and freezing should have looked at that at the time and said, what impact is this going to have on our bottom line? They might have then said to Hunter Council, how about we put that maximum at 5%? They didn't do that for whatever reason.
I think if I saw that clause, I'd be saying, well, all the rest of the agreement presumably has all of the bases on which you can put your price up or down. What do you think is missing here? Because let's have a specific clause about that. Still, these agreements go over really long periods of time. What year is that case? I haven't got it there. I can't remember. Somebody actually, you've got the casebook there. Do you want to have a quick look at the case?
1968.
1968, so pre-privatisation. Probably privatisation wasn't even on the radar then, but the way that pricing in electricity markets has changed dramatically over that period of time, or the period of time since. So I find that quite ambiguous reading it.
What I don't get is that the supplier wouldn't have been the council. The supplier would have been the state.
Yeah, but they'd probably subcontracting it out. They'd buy it in bulk from the state and out. I don't know how it works. Time 68 was longer ago than I expected, given that of the council. But
And they would probably manage the markets.
It just needed some
Doesn't matter.
formula. It doesn't have any formula.
doesn't have any formula. So does this mean that we think it's ambiguous? It's ambiguous. So should it be void for uncertainty?
I don't think so. I don't think it should be.
Okay, well, Chef, you're in good company because Chief Justice Barwick agrees with you. Like, you know.
I would say it's on chilling and freezing to have better determined that clause if they didn't like it. I mean, if they had good contracts lawyers, they would have picked up on that and said, hey, look, check this out, I think we should.
And basically, Chief Justice Barwick agrees with you. He says, well, the language is not so obscure and so incapable of any definite or precise meaning that the court is unable to attribute to the parties any particular contractual intention. So they're saying, well, look, at the end of the day, yes, it just talks vary, but we understand that it's dealing with putting prices up in a particular way.
Is the ambiguity, is it stemming from like the vary, or is it stemming from the supplier's cost? Because I think it's coming from like what is the supplier's cost?
What is the supplier?
As opposed to like can you vary up or down? Like to me, it's like it's just a shitty clause. Like it's just you're agreeing to have
That's
the
where you
price
need the
up
Latin,
or
the
down.
shitty. Yes. No, well, you're exactly right. That it is a vague clause. But what Chief Justice Barwick says is, well, these are grown-ups dealing in a particular type of contract. It's not so, he doesn't say it's a good clause, right? He goes far from that. He says it's not so obscure and so incapable of any definite meaning to mean that it's wiped out altogether.
He's also assuming that both parties are going to be reasonable, because it's quite possible that one could be unreasonable within that clause.
Well, he says actually that there's no uncertainty or ambiguity in the expression supplier's cost. I disagree with him on that. I think it's very ambiguous actually. But however wide may be the area of possible disagreement as to what it means in a particular case, saying in this case we can understand what it is. So, and it was read to me inputs into the formula under which they achieve the price. So they pay something for the electricity, they then sell it, and there is a margin. So the price that they can charge if they maintain their margin, I don't know whether that was at the same number or the same percentage. It was found that that was not so ambiguous that they couldn't deal with it. So again, why do I pull this case in front of you? Really, at the end of the day, this is a case that shows how low the courts are to find no contract in a circumstance where grown-up commercial people have put a contract together. Now, this case isn't technically about intention of the contract overall, or certainty of the contract from an existence point of view. It went to whether or not that clause itself could be avoided as opposed to the whole of the contract. But the courts are loath to write new clauses for you, to fill gaps where you've left them, or to say that a clause that you have actually signed off on doesn't work. So you cannot look at a draft agreement that your client is about to sign and think, yeah, that'll never be enforceable. I'm not going to worry about it, telling them not to sign that. Now, and the thing, I'll tell you, the number of times I've heard that, particularly in relation to restraints of trade, for the reason of just coming back to the conversation earlier about making humans do stuff. Restraints of trade are contracts where one party agrees that they won't work in a particular industry or for a competitor or in a particular area for a period of time. And they're often drawn really widely. In fact, we call them staggered clauses or waterfall clauses. So think about it. I'm a local hairdresser and I work for you, Sarah, and you employ me on the basis that I have a restraint clause in my contract, that if I cease working for you, I can't set up shop next door and I can't offer my services to the clients of your hairdressing salon. Now that might actually be a reasonable restraint, but if you had a clause that said you're not allowed to be a hairdresser at all for 6 months anywhere in Australia, that probably wouldn't be. But at the same time, this case would suggest that it would be bad legal advice for one of you to say to me, well, don't worry about that, that'll never get enforced, just sign away. So, this brings us to this question of reasonableness.
But there's also that crossing with the intention, saying that if they've seen that clause and they've still signed, then there's an intention to be bound by that clause.
There is a crossing with intention, exactly. And maybe that's in Barwick's mind when he's saying, again, these are grown-up commercial people. These are people with some equality of bargaining power. It's reasonable, he says, or it's not so unreasonable that we can't make sense of that clause in this context. maybe that would be different if we were dealing with bulk home purchase. You know, I enter into, as a domestic user of electricity, I enter into an agreement that says I'm going to pay, whatever it is, $1,000 a year for electricity, and I'll get enough. And there's a clause there somewhere that says, well, if my costs change, we can just change the price. And somebody comes along and tries to up it to $1,500. Different set of circumstances, perhaps. But in this particular case, we're looking at two lots of commercial people. So, often one of the questions that comes up is this idea of, is something reasonable or not? We'll pay a reasonable or a fair price. Sometimes we can work out what that means. We can use an objective benchmark, but sometimes, and Whitlock and Brew is a good example of this, it's just impossible to work that out. So Whitlock and Brew is where we started. It's a particular type of service contract or a particular type of use of the land. We just had no idea what that meant. The other thing that's worth remembering too is that judges themselves might not agree as to what is reasonable or whether something's certain or uncertain. Again, those of you who fall on the side of lover as opposed to fighter, these are the kinds of things you need to be thinking about when you're writing a contract. Are the words that we're using here sufficiently specific and precise to mean that we just avoid this ambiguity? Because it's one thing when we've got a binary question between, is this so uncertain as to be struck out of the contract altogether, as opposed to if we've got multiple potential meanings, we want to make sure that it's the meaning our client intended, is the meaning that a judge is going to agree with. In fact, even better, it's going to be so patently obvious what it means that nobody's ever going to fight over the clause. There endeth the sermon for a moment.
So does that again come back to what you were talking about before with the so when we were looking at for example, referring back to our assignment in the heads of agreement with the business sale of shares. So looking at that precedent and using terminology and I guess...
Well, I think you're going to, when you're looking at that particular, start by looking at the agreement itself or the document that the parties have signed, or one of the parties has signed. Note that only one of the parties has signed it at this point. Though the lawyer on the other side seems to think there's an agreement too, based on the communications that they've had. So, and then actually look through and say, okay, do we have certainty here as to what the terms are? Do we have intention as to what the terms are? Can we work, do we have an intention to be bound? Do we have an intention to be bound by some things but not others? Which things? The things that, if we think there's some things that there's an intention to be bound by, what are those things? We have certainty as to what they are. Do we have an offer and acceptance here? Do we have offer at all? Think about those things, but when you're talking to Dennis about what his precedent should do, then you might need to raise with him the necessity for working out certainty. And can you always have, are there some things that will always be the same? And are there some things that he's going to have to turn his mind to every time he pulls that precedent out of the drawer? The virtual drawer, shall we say. All right, to be certain, terms must not be illusory. My son walked in when I had this slide up not long ago and said, "Do you teach magic law?" I thought that was kind of funny. Obviously I'm the only one, but the Hogwarts School of Contract Law would have illusory conditions. So again, our third one. Now remember, sometimes terms will fail all of these tests, only needs to fail one in order for us to not have completeness. So where does this fit? Whoops, back again. So again, we've looked at, are the terms complete? Is the language clear? And then we can ask ourselves, are the promises real? I think that's a more active statement than the negative. Is it not illusory? So what is an illusory promise? An illusory promise is where a party is given such unfettered discretion that the promise itself isn't real. So again, this fits in really neatly with the honour clauses that we spoke about last week. So remember when we were talking about our MMC in particular, it's our policy to do this. In fact, they didn't use the word policy. We will support our subsidiaries, but we won't do it in a way that's going to affect our own cash flows. The reason that we do this business in a subsidiary is because we want to separate our risk from the main business. So yes, we don't like it when our subsidiaries disappear, and we do things to stop that happening. And we'll tell you, we'll give you this letter of comfort and support, but we're not making you any promises. So that's another area in which those cases could have fallen apart. Also, terms are essentially, yeah, I promise I'll do it, but you don't have any remedy against me if I don't. So placer development is a good one to look at here. It's in your case book. So what happened in placer? Contract. Another one with the Commonwealth. Very hard to get a contract with the Commonwealth, isn't it? The Commonwealth will pay to this particular timber company a subsidy on the exportation of these products from the territory of an amount or at a rate determined by the Commonwealth from time to time, but the subsidy will not exceed the amount of customs duty that you have paid. In other words, we want you to export timber. At the moment, timber is subject to a duty. We'll pay you a subsidy that'll pretty much match the duty if we feel like it. Well, it doesn't say if we feel like it. We'll pay you a subsidy that may or may not do that. It won't be more than the duty, but that's what we're going to do. So the question became, was that a real promise? Justice Kiddo said, as a general principle, wherever words by which themselves constitute a promise are accompanied by words showing that the promisor is to have discretion or an option as to whether he will carry out that which purports to be the promise, the result is that there is no contract. I will pay you if you clean your room. I'll decide how much later if I feel like it. Promise of every mother ever to their teenage son. Of course, we might have an intention issue there as well.
Does this negate the earlier one?
Sorry?
The earlier result with the freezer company?
So how are they different? So I'm going to say no, I don't think they're the same thing. But think about how they're different. So Hunter Chilling, or Hunter Council and the freezer and chilling case, in that the contract said the council can vary its price based on changes to its cost. That was pretty vague in a whole heap of ways, but there was, we can vary it if our costs increase. And I suspect the only way it could be read sensibly was we can vary it in line with that increase or that change to our cost. This is basically saying, look at the words on the previous one from the clause, we'll pay you a subsidy at a rate that we determine from time to time. So it could be 0. Could be 0.0001%. It could be anything up to, it's got a cap, it won't exceed the amount of customs duty.
The early one had who determined the increase of sales, like the increase of their cost price. Well, they could have determined, okay, let's pay everyone double market rate.
They didn't argue, but it wasn't argued that it was an illusory promise. Well, it's not really a promise either there. It's a right. They're not promising to increase the price.
Well, they are.
It's a
supply
right.
costs.
But the promise is the benefit. The payment of the price or the calculation of the price is the detriment. Here it's, I promise to do this for you at my discretion. So think about, remember last week we talked about Shahid and the Royal Dermatologists Association. Now really that case was really around, if you're going to conduct yourself like it's a contract, you're going to require consideration and you're going to set out a group of a set of rules, then you can't then later on say, well, I didn't intend for it to be a contract really. That's too late. But another approach that they might have taken was it an illusory promise? I'm promising that I am going to review your right to become a member, but I don't really have to, and I can exercise whatever discretion I want to in relation to that. Just.
So you're saying as long as the promisor can decide whether or not he wants to do it, it's illusory?
Pretty much. Yeah, if it's absolute, if they've got unfettered discretion.
I read this one last night, I think. The Commonwealth will pay. It could be $1, but I don't know, I didn't really read it that way.
So Kira is basically saying here, if your words that constitute the promise are accompanied by words showing that you have discretion as to whether or not you're going to carry that out, then that makes it illusory. So
I see the reason.
I promise to give everybody an HD if I feel like it.
But it more just says we'll pay at a rate they decide. The rate might be broadly unacceptable, but it will still be a subsidy.
So yeah, I can see your argument. The
Could seem
point
to
here
find
is
in favour of the Commonwealth.
we find it is that much more difficult to have a case with a contract with the Commonwealth. So you're seeing a pattern here. Think about lay and the tick eradication. Oh no, nobody ever intended that to be binding. That was just a service that the government was providing. There was no consideration there. What was the other one that we've got? Oh, woolen mills. Seeing it's a little bit more difficult. Now there are other constitutional reasons for that, which I'll leave to you to look at later, but there is a consistency there.
I guess the Commonwealth is deciding whether or not Kiddo gets a pay rise next year anyway. So, I don't know if that's a factor.
Now there are members of there are members of Parliament who've recently been before the Chief Justice in Victoria. In fact, they didn't show up, did they, for contempt for making statements like that. So I think we need to all be a little bit careful in this era where we're not quite sure who our government is and who's eligible to be on it. So what are the exceptions to this? We learn from the exceptions. If a party is given a latitude of choice which doesn't amount to complete and unfettered discretion. So your argument just a moment ago would fit within that. It's like, okay, you can pay anything between a cent and $100, you can choose, but you must pay something. Think about it, I often wonder about this with those, that sort of the newish business model for eating, like lentil as anything and places like that, whereas pay what you can or pay what you think it's worth. Is that an unfettered promise? Is it really a contractual relationship? Does it actually matter? I'm not sure. Where the discretion relates to the fulfilment of a condition upon which the performance of the contract depends. So something like Meehan and Jones, which is the case Sue started talking about and we'll come to in just a moment, but that can somebody else make a decision? So the solicitor's additional terms, for example, or the discretion is to be exercised by a third party. So an independent valuer we just spoke about earlier, but where somebody else comes in and makes a choice. So again, the courts will, on the whole, if it looks like a contract, it smells like a contract, it sounds like a contract, it's made by grown-ups that clearly had intention to contract,
And that aren't the government.
and, unless they're the government. Well, it's easier to find examples of illusory promises with government contracts, and I'll leave it at that. So Meehan and Jones. This is the one that Sue was talking about. I keep saying last week, but it was 2 weeks ago now. This was the contract where, amongst other things, the purchaser needed to receive approval for finance on satisfactory terms in an amount sufficient to complete the purchase under the contract, and there was another condition as well. I can't remember what it is off the top of my head. If those two things weren't done by the 31st of July or another date that they might agree later, then the contract was going to fall over. And then the vendor, basically before the 30th of July, went and sold the property to somebody else and said, oh, well, actually that was an illusory promise. That was an incomplete, lacked certainty, because it doesn't say who, satisfactory to who. Remember, this is the vendor saying, doesn't say who it's satisfactory to. I'm not in breach because I sold to somebody else. So, Jones argued that. So what happened? Chief Justice Gibbs said that the clause required finance to be satisfactory to the purchaser. It was ridiculous to read it any other way, because to read it any other way, if the purchaser's finance had to be satisfactory to the vendor, that effectively gave the vendor an unfettered discretion. And if that happened, that would be an illusory promise. And we don't find illusory promises in contracts with the government, it seems. Now we work on the basis that the parties intended to be parties to a contract. They intended their agreement to be binding. So to have a nonsensical term makes no sense. Because the court was able to assess the purchaser's fulfilment of the standards of honesty and reasonableness, the purchaser's obligation was enforceable, which meant that the contract itself existed. Godecke and Kirwan is the other one that I mentioned just a minute ago. In that particular contract, there was an offer to purchase land. A clause in a contract provided that the purchasers would, if required by the vendor, sign a further agreement to be prepared by the vendor's solicitors containing all of the things in the heads of agreement and such other covenants and conditions as they may reasonably require. The vendor decided to pull out and said, well, that's just an unfettered discretion. So in that particular case, it was still held that the agreement was binding because it was a third party that was putting in the additional clauses. And it allowed the vendor's solicitors to add terms unilaterally, but this discretion was being exercised by a third party, not by the vendor themselves. So remember here, it's the vendor who was refusing to proceed though, and arguing that they shouldn't proceed because they effectively had unfettered discretion. And the court says, well, no, you don't actually. And what you have is a third party has this ability to turn this into a formal agreement. Note, a promise can be both illusory and uncertain. And we've spoken about that a couple of times. So let's talk about biotech and pace. So, pace, I should say. Anybody had a look at this case? I like this particular one because this is kind of the area that I spend quite a lot of my professional life in, working with startups. So Dr. Pace was a biotech dude of some sort, and he got swayed away from whatever university he worked at to come and work for a startup called Biotechnology and Pace. Biotechnology Australia, I should say. I'll just read from the terms of the contract if I can. He was going to be paid, the premise was some of $36,000 a year. He was going to get a car, and he was going to participate in the share option plan. I don't think it had exactly those words. The Senior Staff Equity Sharing Scheme. Now, when he signed up, he knew that there was no such thing as an equity sharing scheme. It hadn't been created yet. It's something that they were going to do, but when it came into place, the intention was that he would be part of it. He worked there for a little while and it didn't work out. So he went to work somewhere else, he left, and he sued them for damages in respect for their failure to ever let him participate in the Senior Staff Equity Sharing Scheme. So does anybody know what a Senior Staff Equity Sharing Scheme is or a stock option scheme is? Do you know what they entail? So anybody watched any pop TV about Silicon Valley? There's a show called Silicon Valley. Really funny. Just none of you are into this startup culture. I feel so much more at home with my MBAs.
It's good.
It is fun. The whole of Silicon Valley, the whole startup culture is built on this idea of stock options. You come and you work somewhere for free for a little while, and the company goes public, you get shares, you're a billionaire. All those Facebook billionaires, all those Google billionaires, that's where they come from. They worked for free or for cheap early on in a company that made good. For every one of those, there are a couple of hundred that never make it, right? So people are moving around from one company to the next, hoping to get the stock options that work. So a stock option is, we know what an option is. So an option is essentially an enforceable promise to be able to buy something in the future. So a stock option or a share option is literally that. It's a contract that a company has with a person or another company, a promise to issue shares at a future time at an agreed price or a price that can be determined by a formula, often zero or a very small amount of money, to somebody in exchange for work that they do. Now, there's a whole heap of complexities around it. So I've spent a lot of sleepless nights in my life trying to work out stock options, because you can imagine there are tax issues. If you get something in exchange for work, you have to pay tax on it. It's very hard to pay tax on something that might never be worth anything. There's all sorts of complexities around them. But that's basically what Dr. Pace has signed up for. I'm going to come and work for you, Biotechnology Australia. I'm going to get $36,000. You're going to give me a car. I'm going to help you succeed, and I'm going to participate in the share equity plan. Then it turned out it didn't work, and so he sued them after he left for his share of the senior staff equity plan. Based on where we've got to today, even if you haven't had a look at the case, what do you think happened next? Would he have been successful? No. All right, you're going to represent Biotech Australia then. Have I got anybody who thinks he should have been successful? My little friend, would you like to give me some arguments as to why you think that Biotech should not have to pay this hard-working scientist what was promised to him?
It was a promise for a future.
Promise for the future?
Yeah, so illusory.
Agreement to agree, or an illusory?
Yeah.
So what's illusory about this? He's going to participate in the stock option scheme or the senior staff equity scheme.
Had he still been working there yet? But since he was.
Well, he just said he was going to participate, didn't say he had to keep working there. The letter of offer says he will get $36,000, tick, for as long as he works there. We can understand that. Then he'd get a car that he could use while he worked there, tick, and he will participate for coming on board, he'll participate in the senior staff equity scheme. He came on board, he worked there for a while.
Theoretically though,
Why
then
shouldn't
he could quit the next day and still
Okay,
get
let's
that
pretend
offer.
he didn't. I don't think he did.
No, I think yes, he should be entitled to it, because if at the time he was working it was available, then he could have participated in
If it was there at the time that
if it was stated.
at the time he came in, didn't exist yet.
Yeah.
So this is actually where we end up with more of an issue with certainty. Because we don't even know what it is. We don't know how many shares. We don't know how much you would have to pay if you have to pay anything at all. We don't know if you would just get a lump sum for being there, or if you would get more if you performed well and less if you performed badly. We don't have any certainty around what it means. Do I have to go somewhere? I don't mean to pick on you. I'm just like, got to tease out. So Justice Kirby, our old friend, says that we need to look at this objectively. The appeal illustrates a tension. Oh, maybe I should turn the power on, do we think? There we go. Sorry about that. The appeal illustrates a tension which exists in the law between the desire of the courts to uphold and not frustrate a contract and the unwillingness of courts to uphold contractual terms that are unacceptably ambiguous or uncertain. This is the whole point that I'm making today. Courts think if you're grown-ups, it looks like a contract, it smells like a contract, it quacks like a contract, then it's a contract. But the courts will not add terms. They won't fill in the stuff that you haven't thought about. But at the same time, if they can find a reasonable way to make sense of something, that's the approach that they're going to take. So think about that when you look at the documents for that second assignment. So Kirby actually goes on really helpfully here to talk about what the courts won't do. Courts will not spell out to an unacceptable extent that which the parties have themselves failed to agree. The courts will not clarify that which is irredeemably obscure. And the courts will not accept for itself a discretion which the parties have by their agreement reserved to one or other of them. If one party has a discretion, that party gets to exercise that discretion. But if that discretion is so unfettered that it renders the promise nugatory, to use that terrible term, the court won't step in. There just won't be a promise. The courts will pay regard to the features of the agreement, the relationships between the parties, and to relevant external reference points in order to resolve an uncertain term. So in Hunter Valley, that's what they did. They looked at relevant external reference points. They said, these are commercial people who've reached an agreement. We can read this in a sensible way. So Kirby gives us, as he's wont to do, a two-part test. I do like a two-part test, or a test where we can go through each of the steps. Firstly, we ask ourselves, was the promise so devoid of meaning and so dependent upon the promisor as to be illusory? But we also need to ask, was the promise so uncertain in content that it cannot be enforced, even as elaborated by admissible extrinsic evidence? So is there anything else out there? If it's so broad and vague and so unfettered as to be illusory, do we need to bring something from outside to make sense? And if we can bring something outside to make sense, then we can do that. So, in applying the test in relation to Dr. Pace, they said, well, the term is illusory because the fulfilment of the term relating to the equity sharing scheme is dependent upon the decision of one party, the company, and there wasn't any external standard. There is no set form for dealing with senior staff equity sharing schemes. And then secondly, the term is void for uncertainty because there are too many elements that are uncertain. Number of shares, the class of shares, how much do you have to pay, what rights would attach, how long did he have to stay to get there, how was he able to sell them, could he share them with somebody else? All of those things were left completely open. So each case will depend on its own facts. The meaning of agreements need to be discovered objectively.
So, can you go to that two-part test?
Yeah.
So, was the promise void of meaning? And then, was the promise so uncertain in content? What if you've got one of those?
Well, if you don't have both, sorry, so if the answer to the first one is yes, then we need to ask question 2.
Yeah.
If the answer to the first one is no, then we don't really have an illusory issue. But then we will still ask 2 because it may well be that we lack uncertainty. So in case it was a no-no,
Yeah.
we might have a yes. So using this test, if we could apply this to Hunter Chilling, might be, well, the first answer is no, it wasn't an illusory promise, and we could make sense of it. So that was a no, yes.
Yeah.
Each time, because remember
So would you still need to go to number 2 if you've already said yes, it was an illusory?
No, well, because you need to look at both. So they're saying in this one that's a no. So look at the second, can we make sense of it? Can we fetter the discretion in some way? All right. They are the key points that I want to make about this until we think about what the consequences are. So the reason we've explored this here is in working out, do we have a contract? Asking ourselves these contract existence questions. So these questions about certainty also go to the individual provisions and reading a contract. So I want you to think about the circumstances. So can an uncertainty be cured? And that's when we go into these additional bits on my flow chart, that question about whether an offending term can be severed or whether the term itself can be waived. So let's have a look at this. So firstly, one of the things we need to understand is the term itself, or is the uncertainty such that the agreement itself will be void? So if the agreement is void, then none of the terms can be enforced. The agreement itself, we don't have an agreement. So the lack of essential terms, so the failure to actually address essential terms, means that we have no agreement. We don't have all of the formation elements. Whitlock and Brew is a good example of this. No contract, do not pass go, do not collect $200. However, if the offending term could be taken out of the contract, the question becomes, does the whole contract fall over still? Or can we have this contract continue to exist with that offending term, that offending provision pulled out of it? If we can, then we can still have a valid contract. We just had the removal of that term. So in Hunter Valley, for example, that's what Freezer and Chilling Company wanted. They wanted to say, that term's so uncertain, it's void for uncertainty, that term should be taken out of our agreement altogether. They weren't arguing the whole contract should fall over. We never had a contract in the first place. So the test becomes, can the contract continue? And Fitzgerald and Masters, which is dealt with in your textbook, I'm not going to go through it here, looks at that as an example. And then the next one is, can the term be waived? So that's the unfettered discretion issue. So if you have an unfettered discretion, so let's use the, I promise to sell you my shares, I'll sell you my shares, you're going to agree to buy them subject to finance, which at your absolute discretion needs to be suitable to you. So, and it's really broad, you've got absolute discretion as to whether or not you can buy or not. You can waive that discretion and I'm still bound by the contract. I can't waive it because you've got the benefit of it. If you want to exercise that discretion, I can walk away because the contract itself will fall over. But if the rest of the contract exists, you've got a broad unfettered discretion and you can waive the right that you have, then the rest of the contract can live. Does that make sense? So when is the whole contract void? Factors leading to the conclusion the whole contract is void really go to, are we missing an essential term? So when we went and looked at what those essential terms are, can we not identify what piece of land we're talking about? Can we not identify who the parties are? Are we vague and uncertain as to what the price is or how it's going to be calculated? If we fail on an essential term, then chances are the whole of the agreement fails. When can it be severed? If the term itself isn't an essential term, so again, one of the reasons why Freezer and Chilling Company would have argued that the term about variation of the price was a void term is because it wasn't an essential term of the contract. It was a term that breach of which would result in damages as opposed to being able to pull the whole contract apart.
So the court would decide if it's to be severed or not.
Yeah, the court, so in determining whether it's going to be severed or not, or able to be severed or not, court needs to come to the view that the contract itself makes sense without that clause. And that test for essential terms is essentially, is it so key to the contract making sense to the parties reaching an agreement that it needs to be there? Can you substitute something else? So again, the example I used earlier is a contract for the sale of a house. You can't substitute a different house. But a contract for the sale of a bushel of apples, whatever a bushel of apples is, you might have your eye on that bushel over there, but it can still be fulfilled by another bushel from over there. It doesn't matter, unless they're different apples, I guess. So, can you see how this becomes quite not only relevant to the question of whether a contract exists, but to how a contract might be enforced moving forward. So the next topic that we have is formalities, but I'd like to actually, just looking at the time and what I can do usefully with it. I've got some recordings in relation to formalities and I will pull that back. I think that it would be quite good to start an activity, but I'm not sure that we can get very far with it in 25 minutes, and in fact we probably want to finish 10 minutes before that for people to catch trains. Looking at Michelle. I'm just trying to look, I'm gathering the energy in the room. I'm happy to continue with an activity now. I'm also happy to stop us right now and head to the station myself. I'm also happy to start formalities. Is there, what would do people want to do, given that we've ended up with this kind of awkward time? Happy to finish?
I'm a hit.
Okay. I'm seeing some thumbs up. Anybody who's not happy to finish, please complain to me rather than your classmates. Why don't we finish up now? I'm going to ask you to look at formalities videos, which is annoying for some of you, I get that, but I would really like to go into doing a little bit of an activity first thing next week to make sure that we consolidate and pull all of these pieces together. And so next week, we're now actually one topic behind, remembering that the topics should be covered over like 2 a week at the moment. So next week we've got 3 to cover. So I would really appreciate it if you can have a look at formalities in advance. Now, they all come together. Topics are not of equal weight and size.